The following program, offered by Fox 19, includes lawyers licensed in Kentucky. For those lawyers to maintain compliance with the Kentucky Bar Association requirements, the phrase, "This is an advertisement," must appear on the screen. Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Welcome to Moore Law. You know the drill. We are taking your legal questions live on the air with a different topic each week. Today we are talking about on-the-job injuries. A lot of times injured workers don't know their options until it's too late. You might not know if you qualify for workers' comp, if you can pick your own doctor, how long your benefits last. It is a tough spot to be in. Now, if you have been injured at work and you don't know what to do, give us a call at 513-421-4691. Before we go to the phones, though, let's take a look at what is coming up over the next couple of weeks. May 28th, we'll be talking about traffic accidents. June 4th, Meet the Police Chief. And June 11th, Crime and Punishment. Here with me today, as on every Monday, Don Moore. How are you today?
I'm doing great. How you doing, Deb?
Good. It was a good weekend, I'm sure.
It was. Enjoyed some of that sunshine. I understand you got out and saw a few softball games.
You can't beat the soccer, the softball, the baseball. I had to fit a little weeding in there, but, you know, a little play, a little fun.
Very domestic.
Well, yes, but it was also an excuse to be out in the sun.
Amen, amen. Hey, today we're going to talk about hurt on the job, and Mike Weber is here with us. Mike's been practicing for over 23 years, and that's what he does. Mike, thanks a lot for coming.
Hey, thank you very much for having me. I'm very excited to be here and happy that you had me.
Well, Mike, tell us a little bit about what you do and I guess what makes your phone ring.
Well, my practice is I've been a workers' comp lawyer now for 23 years. We're certified as a specialist by the Ohio State Bar Association in that field. And then also we do both Ohio and Kentucky workers' comp law. That's far and above our primary focus at the law firm. And you know, what we find is we help people who are hurt on the job. We only represent injured workers, and it's a very frustrating system, workman's comp. And, you know, they get tired of, you know, all the hurdles in addition to, you know, not just trying to get healthy, but also working their way through a legal system.
And well, hopefully we can help navigate that a little bit today. And Don, I think you wanted to start with some examples of other causes.
I did. There are other causes where people can get hurt on the job and they don't just have workers' comp, because as Mike I'm sure will explain later, you don't get all your compensation for workers' comp, you don't get all your wages, and you don't have control necessarily over what you can be treated for, and so there's limitations. And there's other options. If you're a driver and a third party runs into you and causes a wreck and hurts you, you've got a workers' comp claim if you're doing that on the job, but you've also got a claim against the other driver. I had a case not too awfully long ago where a product exploded in a power plant, killed some people. They had workers' compensation claims, but they also had a claim against that product manufacturer that made the product that exploded, or a double cycling punch press, or just there's all kinds of things where causes arise. And I do the personal injury end of it. Mike does the workers' comp, and oftentimes it takes two lawyers to actually represent somebody in a case like that. Now, Mike, you've had circumstances like that, haven't you?
Absolutely. We see automobile accidents on the job on a regular basis, and not only do you have the workers' comp claim for the injuries suffered in the accident, but you also have the claim against the driver who may have caused that accident, yeah. And so you've got a third-party claim.
So our show today isn't just about workers' compensation, although that's the primary thrust because Mike has so much experience doing that. It is also about other injuries that may occur on the job in addition to, or causes that may be in addition to workers' comp.
Okay, and I think we have an example of one of those right now. We have Jay in Middletown. Jay, you were hurt on the job, is that right?
Yes, I was hurt at a hospital in Cincinnati, and I worked there as an emergency tech in the ER. And I got my back broken, and I have a cage now, and they're what's called self-insured.
Okay.
And my problem is they're saying I've reached my medical maximum improvement, but yet they don't approve nothing. So my question is, you have to jump all over these hurdles to get healthy, but yet the self-insured people get away with not following the Ohio BWC rules. And from my understanding is if you're in a self-insured hospital or employer, you're supposed to follow BWC rules. How do you get them to follow the rules? Who do you go to next?
Right, and Mike, you and I were talking about this before the show, that it's difficult because people are trying to get well, and then they're trying to fight a system, and then it just seems insurmountable.
Sure, it's very frustrating because you're trying to get healthy. That's your focus. That's a very serious injury, and also you're jumping through the hoops of dealing with workman's comp, but you're also dealing with a self-insured employer. While they're actually held to the same legal standard, the same laws, they have more autonomy because they manage their cases themselves versus being managed by workman's comp.
Okay.
So, in the event that an employer doesn't have workers' comp, they haven't paid the premium and they haven't done what they're supposed to do, in that event, the worker can still follow the same rules against the Bureau of Workers' Comp of Ohio, and then they later chase the employer. Is that right?
Absolutely. You still have coverage even if you don't have an insured employer. That's the same in both Ohio and Kentucky.
Yeah. Great.
For the caller, what I would potentially suggest is, you want to be sure that you've got the correct conditions recognized in your claim. You want to, file appropriate motions because they will be held to the standard by the Industrial Commission, which is where the hearings are held, and they will make the rulings against the self-insured employer.
Okay. Let's see if we can get through a couple more calls here before the next break. We have Cliff in Cheviot. Cliff?
Yes, good morning.
Good morning.
My question is, if you're on permanent total disability, how long does that last? Does it quit when you're 65 or 66, retirement age, or does it go on?
Are you in Ohio or Kentucky?
I'm in Ohio.
Permanent total disability will last for the rest of your life.
And I think it brings home the point that I think in both of your practices, where you live makes a big difference when you talk about statute of limitations and just the rules governing whatever the issues are.
And I think that's a great question. And my understanding from what you said is that it doesn't stop when the worker gets to be 65 if he's got permanent total in Ohio. It goes on until he passes, if he's 80, 90, whatever it is.
Absolutely. He will have those benefits for the rest of his life, medical and wage benefits.
Okay, very good.
Is that something that do people call you because they're at the end of the rope, or are they just confused? I mean, do people call you because they go into a courtroom and they realize they're standing there by themselves and the company has help?
That's probably the main reason that people would call in and meet with an attorney, is because they go down and have a hearing and they suddenly realize that the Bureau has attorneys that attend hearings, the employer have representatives and attorneys that attend hearings, and they're held to the same standard in front of the judge, and they're there by themselves in a very confusing system.
In a very confusing situation, I'm sure. Yeah. We have another call now. Deborah in Kentucky. Go ahead, Deborah.
Hey, how are you doing?
I'm doing good. How are you?
I'm okay.
Let us know a little bit about what's going on with you.
Well, I've been off of work for about 2.5 months. My job entails standing on my feet all day, and as a result, I've acquired a stress fracture in my ankle and up my leg, my tibia. The doctor that I'm seeing he has stated that it's like a repetitive carpal tunnel type situation. I didn't actually, fall over a skid and broke my leg. It was a recurrent, ongoing thing. I've been denied twice by workman's comp, even though the doctor has said it is work-related, and I'm not sure what my next step should be.
Actually, a lot of people have problems sometimes proving that their injury or their medical condition was a result of work. Isn't that right?
Absolutely, yeah. And age-related conditions are excluded from workman's comp. You still have to be able to show that there was an injury, even if it's a repetitive trauma situation.
And now I understand we're all over Ohio today. I think we have Kathy from Cleveland on the phone. Kathy, go ahead and tell us what's up with you.
Yes, I also had an injury. Well, I had a total knee replacement, and I was on FMLA. I came back from FMLA, and my employers had me walking up like 50 steps. I was on a cane, and my doctor kept giving them restriction letters, a total of 5 in all within the 4-month period. They just wouldn't adhere to the restriction letter. So I end up having my right knee is now messed up, and I'm going to my doctor and now. I'm having cortisone shots taken in my right knee, which is I'm probably going to end up having a knee replacement on that as well. And I was wondering if there was anything that I could do about that, because they were well aware, and I would complain, but I guess if I wanted to keep my job, I had to continue to do so.
Well, assuming that the left knee was an injury with workman's comp, because it is causing problems with the right knee with, say, an altered gait, that's what's known as a flow-through injury, and it could be an additional condition, what is occurring in the right knee, and could be added into the claim, and then workman's comp would be responsible for that.
Isn't that also what they sometimes call a sympathetic injury as well, where you've got basically, I've hurt my right leg because of what I do to protect my right leg, I wind up overstressing my left leg and wind up with a sympathetic or the flow-through injury? Absolutely.
In workman's comp's world, it's called flow-through more than anything else. But yeah, that's one method you can have a condition recognized in a claim.
All right.
Okay.
Deborah, or Kathy, we hope that you are feeling better and get that worked out. In the meantime, we are going to take a break. We'll be right back with more law, what to do if you've been hurt on the job.